Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. So today we're going to talk about two of the cases that sovereign citizens can never find. And I'll show you why. Hang on. So if you were to go Google, what can a police officer do when he stops your car? Or what can a police officer do when he stops you out in public? You would come across these two cases. They're Supreme Court cases. They're the law of the land. And they don't appear to be in the bailiwick of the people who claim to be sovereign citizens. So today we're going to look first at Terry versus Ohio. Now, Terry versus Ohio is the case that gives us the investigative stop. In other words, the whole basis of this is it gives you the right, if you're a police officer and you have a reasonable, articulable suspicion that someone has either committed a crime or is about to commit a crime, you can conduct an investigative stop. Well, how did that come about? Well, it came about in this case. Let me tell you a little bit about the facts. A Cleveland detective on a downtown beat, which he had been patrolling for many years, observed two strangers, petitioner, in this case Terry, and another man, Chilton, on a street corner. He saw them proceed alternately back and forth along an identical route, pausing to stare in the same store window, which they did for a total of about 24 times. Each completion of the route was followed by a conference between the two on a corner, at one of which they were joined by a third man, Katz, who left swiftly. Suspecting the two men of casing a job, a stick-up, the officer followed them and saw them rejoin the third man a couple of blocks away in front of a store. The officer approached the three, identified himself as a policeman, and asked their names. The men mumbled something, whereupon McFadden spun petitioner around, patted down his outside clothing, and found in his overcoat pocket, but was unable to remove, a pistol. The officer ordered the three into the store. He removed the petitioner's overcoat, took out the revolver, ordered the three to face the wall with their hands raised. He patted down the outer clothing of Chilton and Katz and seized a revolver from Chilton's outside overcoat pocket. He did not put his hands under the outer garments of Katz, since he discovered nothing in his pat-down which might have been a weapon, or under petitioner's or Chilton's outer garments until he felt guns. The three were taken to the station. Petitioner and Chilton were charged with carrying concealed weapons. So this is a situation where the defense raises the issue of whether this was a search and seizure under the Fourth Amendment. Well, how does the Supreme Court handle that? Well, here's what it says, among other things. First, the Fourth Amendment right against unreasonable searches and seizures made applicable to the states of the 14th Amendment protects people, not places, and therefore applies as much to the citizen on the streets as well as at home or elsewhere. This is a very important part of this holding, and it's often overlooked. It protects people, not places. Now, a lot of the cases deal with places that are searched, but it is designed to protect the citizen from government overreach. The issue in this case is not the abstract propriety of the police conduct, but the admissibility against petitioner of the evidence uncovered. Now, the reason it reached the Supreme Court is because the Ohio Supreme Court said, you violated the Fourth Amendment rights of these two, and the evidence has to be suppressed. And of course, without the evidence of a concealed firearm, well, you don't have a case against a person for a concealed firearm. The exclusionary rule cannot properly be invoked to exclude the products of legitimate and restrained police investigative techniques, and this court's approval of such techniques should not discourage remedies other than the exclusionary rule to curtail police abuses for which that is not an effective sanction. The Fourth Amendment applies to stop and frisk procedures such as those followed here. Whenever a police officer accosts an individual and restrains his freedom to walk away, he has seized that person within the meaning of the Fourth Amendment. So this is important. If you are ever stopped and you say, I don't want to have a discussion with you, Mr. Nice Police Officer, and they tell you you are not free to go, you have been seized within the meaning of the Fourth Amendment, which means they have to have a reasonable, articulable suspicion that you have committed a crime. And if they don't have that reasonable, articulable suspicion, then the detention and the stop are unlawful. B. A careful exploration of the outer surfaces of a person's clothing in an attempt to find weapons is a search under that amendment. Moving right along, the Supreme Court took it a little bit further. When a reasonably prudent officer is warranted in the circumstances of a given case in believing that his safety or that of others is endangered, he may make a reasonable search for weapons of the person believed by him to be armed and dangerous, regardless of whether he has probable cause to arrest that individual for crime or the absolute certainty that the individual is armed. In other words, if an officer has a reasonable belief that you are armed, then he has the right to stop and frisk you. But here is an interesting piece of this, and it's going to have to be litigated because in many states now, it is perfectly appropriate to carry a concealed firearm and walk around armed. So in those constitutional carry states, does this apply? We're going to have to wait for the Supreme Court to let us know. It says the officer was performing a legitimate function of investigating suspicious conduct. He was justified in believing that an individual whose suspicious behavior he is investigating at close range is armed may neutralize the threat of physical harm, take necessary measures to determine whether that person is carrying a weapon. And an officer may make an intrusion short of arrest where he has reasonable apprehension of danger before being possessed of information justifying arrest. The officer's protective seizure of petitioner and his companions and the limited search which he made were reasonable both at their inception and as conducted. Now, why were they reasonable? They were reasonable for several reasons. One, he could articulate conduct that most people don't engage in. Walking up and down, peering in a store window, and walking back and forth, having a conference with other people, and continuing to repeat that behavior. That behavior signals that somebody is doing something they probably should not be doing, and that there may be a risk of criminal activity going on. Now, at the end of the day, the Supreme Court upheld this, and it has become known in lingo as a Terry stop. What are the things necessary for a Terry stop? Well, one, a reasonable, articulable suspicion that either someone is armed or up to criminal activity, and the need to protect oneself from being harmed. So there are a couple of ways this could play out in the constitutional carry states. For example, the officer sees Cletus, and Cletus is walking around. He's got a big bulge under his jacket, and he knows Cletus because he's arrested him before. He knows that he's a convicted felon, and convicted felons are not allowed to be in possession of firearms. In that situation, he would have a reasonable suspicion justifying a Terry stop. Now, Alabama, however, is a constitutional carry state, as is Missouri. So if I'm walking around and I have a bulge in my outside of my pants, or that the police officer can detect by looking at me, he doesn't have a reasonable articulable suspicion that I'm up to no good unless I'm engaging in behavior like the people in Terry did. But if all he sees is a firearm, or believes that to be a firearm, and doesn't know that I'm engaged in criminal activity, it is unlikely that his detention would be lawful. So that's the parameters of the Terry stop. And now let's get into the issue of the right of a police officer during a traffic stop. And this case is Pennsylvania versus Mimms. Let's talk a little bit about the parameters of that case. After police officers stopped respondent's automobile for being operated with an expired license plate, one of the officers asked the respondent to step out of the car and produce his license and registration. As the respondent alighted, a large bulge under his jacket was noticed by the officer, who thereupon frisked him and found a loaded revolver. Respondent was then arrested and subsequently indicted for carrying a concealed weapon and unlicensed firearm. His motion to suppress the revolver was denied, and after a trial at which the revolver was introduced into evidence, he was convicted. The Pennsylvania Supreme Court reversed on the ground that the revolver was seized in violation of the Fourth Amendment. Here, the Supreme Court looked at it a little bit differently because it had just decided Terry versus Ohio. And in Terry versus Ohio, they said, look, if you believe somebody is armed, you have a right to protect yourself. So the issue really became whether it was lawful for him to order him out of the car. Here's what the Supreme Court said. The order to get out of the car issued after respondent was lawfully detained was reasonable and thus permissible under the Fourth Amendment. The state's proffered justification for such an order, the officer's safety, is both legitimate and weighty, and the intrusion into respondent's personal liberty occasioned by the order, being at most a mere inconvenience, cannot prevail when balanced against legitimate concerns for the officer's safety. So one of the things you will see officers do a lot in videos is they will talk about officer safety. I need you to step back and not film this encounter you have to go back at least 25 feet. That's for officer safety. And of course, it's also for the safety of the person filming, because if the person that they're investigating pulls a gun and starts shooting people, it's always the innocent bystanders who get hit first. Anyway, to make a long story short, or perhaps shorten a long story, whichever way you want to look at it, the right of the police to ask you to get out of the car is absolute. You can do that. Now, this traffic stop has to be for a legitimate reason. It can't be a DWB, driving while black, or DWH, driving while Hispanic. It has to be an expired license plate, a light that's out. It has to be someone was speeding, crossing double yellow lines, doing something that violated a traffic rule or regulation, and then the traffic stop is legitimate. Once the traffic stop is legitimate, they can order you out of the car. Now, most of us go around all the time without having to worry about our cars being searched and seized because we A, obey traffic regulations, and B, don't engage in criminal conduct. Sovereign citizens, however, are often not equipped with license plates, they're not equipped with driver's licenses, and in many jurisdictions, the officers already know who they are. And of course, what's the first thing they say when they're ordered out of the car? You don't have the authority to do that. A lot of times, in fact, in a recent case in Florida, a gentleman told the highway patrol that they couldn't order him out of the car. Only the local sheriff had the authority to come and seize him. Again, I don't know where these myths come from, but the sheriff did have the authority, but so did the Florida Highway Patrol. As a result, this gentleman wound up getting in a world of trouble because he had a concealed firearm in the truck, and as a result of having that firearm in the truck without a conceal and carry permit, he wound up getting arrested, and he will likely wind up doing jail time as a result. Now, some of you may have seen the video that's out there of the mom and dad who were driving with two kids, and they tried this "I'm not driving, I'm traveling" stuff. And then when the highway patrol officer summoned his supervisor, and the supervisor said, "You're coming out of the car," he said, "No, you don't have the authority to do that." The highway patrolman said, "Yes, I do, and you're coming out of that car whether you want to or not." And so in front of his kids, this guy gets pulled out of his car. It upsets the kids. What kind of parenting is that? It doesn't make a lot of sense. So that's what I have for you today, Pennsylvania versus Mims and Terry versus Ohio, the two cases most often referenced in traffic stops and investigative stops. If you have any questions, please leave them in the comments down below. And of course, as always, like, share, subscribe, and thank you so much for watching. Have a terrific day. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.